So the court then comes to the treaty between Denmark and Sweden, and one must remember here that there is no bilateral treaty between Denmark and Sweden, but there's actually the Nordic Convention, which includes Norway as well in the treaty, but it's different than standard bilateral treaties in many respects. For instance, allowing for specific clauses about SAS, the airline company owned by the three states. But it also does follow the Model Convention in some respects. And when it comes to Article 3.2, it seems to have the similar text as the OECD Article 3.2. So the court starts by saying the question then is how the term beneficial owner in the double tax agreement is to be understood in DTA, in this case meaning the Nordic Convention. And then it says the Nordic Convention does not contain a definition of the term beneficial owner, and Article 3.2 of the agreement provides that unless the context otherwise requires, any term not defined in the agreement shall be given the meaning which it has under the law of the contracting state concerning the taxes covered by the agreement, right? And then you look at Danish law, and the court concludes that Danish law is not seen to apply the concept of beneficial owner, which is also not a defined concept on Danish law. And then the court says, but we do have the right to go to the OECD, and the OECD Model Convention does not define beneficial owner, but the commentaries do talk about it. And then the court refers to the commentaries and says, accordingly, the commentary from 2003 OECD Model Convention states that the term beneficial owner is not used in a narrow technical sense, but must be read in context and in the light of the objection and purpose of the convention, including the avoidance of double taxation and prevention of tax evasion and avoidance, right? And then it also refers to Article 11, where they talk about artificial arrangements, and it finally says, finally also in line with the 1977 commentary, the OECD Committee on Fiscal Affairs has concluded on the basis that a pass-through entity cannot normally be considered the beneficial owner if it in fact has narrow powers, which makes it a nullity or trustee acting on behalf of the other parties. And it's in line with this commentary on Article 11, where they talk about conduit arrangements. And basically, you're not the beneficial owner if you are in such a conduit arrangement. And the court then comes to a conclusion. It says the court considers that the loan between Newcomet AS and Newcomet Sweden Holding AB, the simultaneous loan between Newcomet Sweden Holding AB 1 and Newcomet Sikar, the capital increase in Newcomet Sweden Holding 2 AB, and the annual adoption of group contributions from Newcomet Sweden Holding 2 AB to Newcomet Sweden Holding 1 must be regarded as a single and pre-arranged arrangement. And what goes on here, if you remember the structure that we looked at, the top Danish company had a loan from a bottom Swedish company, right, which was totally financed by equity. In other words, that interest income was in principle taxable in Sweden. But then the top Swedish company had a loan in its turn from the Luxembourg Sikar. And the interest deduction of so it had a lot of interest, but it had basically exempt dividend income from its Swedish subsidiary, right? So the Swedish subsidiary owning the Danish subsidiary would receive interest from Denmark, then could pay that out as a dividend to the Swedish parent, which then has a whole lot of interest income but exempt cost, a lot of interest cost but exempt income, and therefore would be paying a lot of tax. But that's not the way it worked, because in Sweden you have a rule which says that if you are in a group, the group members can give you tax deductible gifts, and this is a form of loss compensation within Sweden. So if you have a subsidiary which has a lot of taxable income and you've got a lot of losses, the subsidiaries can give you their income, and you can offset that income against your losses. So you have a kind of a loss consolidation, and this is exactly what Sweden did, right? And then these the payment received then also would have gone to the Sikar, or would have accrued to the Sikar, right? In either situation. But all of these agreements were concluded on one day, even though the taxpayer said yes, but you know what, the tax gift from the Sweden subsidiary to the Swedish parent every year was made on a year-by-year basis. It was not predetermined that this would happen, but the reality is, of course, it would happen. Otherwise, the Swedish parent would be paying a huge amount of Swedish tax or would the Swedish subsidiary would be paying a huge amount of tax on the interest income that it received, and the Swedish parent would have a huge tax loss, which it simply could not utilize because it only had exempt income. So of course there was going to be an annual gift every time. And this is what the court referred to, right? This whole structure, it might look like the Swedish subsidiary is the economic owner of the interest because it doesn't have to pay it on to the Swedish parent other than through a dividend. But in reality, the fact is so that the Swedish subsidiary would every year give its taxable income to the Swedish parent so that the Swedish parent can use that income to offset against its interest cost. And based on these facts, the court comes to a conclusion. It says, an overall assessment of the above facts is found to lead to the conclusion that neither Nycomed Sweden Holding 2 AB, which was the parent of the Danish company, nor Nycomed Sweden Holding 1 AB, which is the Swedish parent, can be considered as the legal owner of the interest. And I think the Google Translate the text here wrong. It might have meant the economic owner of the interest. And the court concludes, as the case stands, the court considers that the interest has definitely accrued to the Luxembourg SICAR. So the Swedish convention or the Nordic convention does not help the taxpayer in this case. So now we come to the Luxembourg-Danish double tax convention to see whether the SICAR can actually be exempt from withholding tax under the treaty, right? So, and then the court says it follows from Article 11 of the Double Tax Convention that interest cannot be taxed in Denmark if the beneficial owner of the interest is a resident in Luxembourg. However, according to the final protocol, this does not apply if the beneficial owner is a holding company subject to special Luxembourg legislation, currently the law of 31 July 1929, so these were the 1929 holding companies, and the Grand Ducal Regulation of 17 December 1938. So if you are a 1929 holding company, then you do not qualify for the exemption from Danish withholding tax on interest, is what it says here. And then the court goes on to say the SICAR is a limited partnership governed by the law of 22 June 2004, i.e. an investment company with capital, with risk capital. To be covered by the law, the company's purpose must be to invest in securities representative of risk capital. And then the court also says the company is not subject to income tax on the income from the investments or from the sale of the investments, right? And now the question is, does the SICAR fall under this protocol or not? And the court argues, it says the final protocol by term covers holding companies, which are characterized being subject to the special Luxembourg legislation for the time being of 1929 and 1938. And I think what Luxembourg meant initially was that, you know, the 29 holding companies were temporary and might be getting rid of later, but the court interprets it slightly different. It says the final protocol must therefore also cover holding companies governed by legislation adopted after 1929, insofar as that legislation has the same specific characteristics as those laws. And then the court says the regional court considers that the SICAR, like the 29 Act, covers holding companies which invest in other companies so that the investments are not accessible to the public. Both type of companies are essentially not subject to tax. In other words, the SICAR is covered by the protocol, is what the court says. Preliminary conclusion, Nycomed SICAR must be regarded as the beneficial owner of the interest in question and is therefore, as a general rule, liable to tax on it pursuant to Article 2.1d of the Corporation Tax Code. So it does recognize the SICAR as the beneficial owner of the interest, but it says, but you don't qualify for the treaty benefits because you look like a 29 holding company. So we now come back to national law and we refer to Article 2.1d, last sentence, and Takeda submits that the tax liability of Nycomed Sweden Holding 2 AB lapses in any event pursuant to Article 2.1d1 1D last sentence, according to which the tax liability is extinguished if the receiving company proves that the foreign corporation tax on the interest is at least 75% of the Danish corporation tax, and that the company which does not pay the interest on, and the company doesn't pay the interest on to another foreign company which is subject to a corporation tax on the interest which is less than 3/4 of the Danish corporation tax. And so Takeda argued that both Nycomed Sweden Holding 2 AB and Nycomed Holding Sweden 1 AB are subject to tax on the interest, respectively, the group contributions in Sweden at a rate of 28%. Now, I mean, this is an argument which is so, in my eyes, weak and contorted that it's hardly worth making. First of all, it was quite clear that in Sweden there was no tax paid because of the group contributions, and secondly, the structure was set up in such a way that no tax should be paid. So should you argue that there could have been tax paid, which wasn't, which seems a bit of a weak bid from a taxpayer's side. And the court wastes no time in throwing this argument out. It says, as stated above, the regional court considers that the interest in question has flowed through to both Nycomed Sweden 2A and 1AB and onto SICAR. And the SICAR is the beneficial owner of the interest and is not taxed on the interest. So we're basically done. First of all, because of this 3/4 tax, and secondly, because the interest has in fact been paid on to a company where the interest was taxed at less than 75% of the Danish corporate tax. That was the first point that was made, and then another point that was made, where I have more sympathy for the taxpayer, is about administrative tax practice. And it says Takeda AS submits that the interpretation of the interest and royalty directive as set out above, and thus Article 2.1d of the incorporation tax, and an understanding of the concept of beneficial owner in the DTA as set out above, constitutes a change in administrative practice with retroactive effect, which, according to administrative law principles, cannot be applied to the interest imputations that took place between 2007 and 2009. And so what the taxpayer says here is, you allowed these structures for years, then all of a sudden you changed your mind and start attacking them with retroactive effect. Now the court debunks this claim, and it says, well, you should have looked at this statement when a law in 2004 was adopted, and you should have looked at this statement when other laws were discussed, and you should have looked at these arguments made by the Danish tax authorities, and you should have known that this was coming. But the fact is that in practice, most tax practitioners, and we're talking about the top lawyers and the top tax professionals in the big four and the big law firms, did not see this coming. They were used to these structures, which is why there are so many Danish beneficial ownership cases going on at the moment. It was pretty common practice. So I have sympathy for the taxpayers' argument, and I like that they use general principles of good government to try and save their case. But the court again rejects the argument. It says, in light of the above, which is these references to legal history in 2004 and statements by the Danish tax authorities, there is no administrative tax practice implying acceptance of arrangements such as the present one. Takeda AS was therefore not entitled to assume that in a situation such as the present, it was exempt from tax on the interest accruals in question, amounting to 50 million euros. I feel sorry for the taxpayer here. And following on that, along the same lines, the court then goes on to talk about the fact that they have not withheld and that they are still liable for the tax that they've not withheld, right? It says, in a case such as the present, where Takeda AS has not fulfilled its withholding obligation, it follows from Article 691 of the Withholding Tax Act that Takeda AS is directly liable to the public tax authorities for payment of the amount due, unless it proves that it was not negligent. Right now, the law doesn't say grossly negligent, but negligent apparently. And the court concludes that Takeda AS must, on the basis of information available, have been aware of the fact that of the facts relating to the interest attribution and the group contributions, including that the purpose of involving Nycomed 2 Sweden Holding 2 AB and Nycomed 1 as intermediaries was solely to avoid Danish withholding tax, as explained above. So it basically said, you know what, you knew what the group structure looked like. You knew why these companies were set up. The taxpayer argued that part of this was done for business purposes. It had very thin arguments for supporting those lines. I think really the taxpayer's strongest argument is still the administrative practice at the time when no one saw this coming. But the court says, you should have known, and therefore you should withhold it. And the court concludes, in these circumstances, the fact that at the time of the interest allocations for 2007-2009, there was no final clarification of how the concept beneficial owner should be interpreted, and thus whether there was sufficient legal basis to counter an abuse of rights such as the present one, cannot lead Takeda being exempted from liability under Article 69 of the Withholding Tax Act. I think the court, I'm not saying they're wrong, but they definitely are particularly harsh in their judgments here, from my point of view. But that closes the case for Takeda. It's been a complex case. I hope you enjoyed following it. I think it helps to put the case into its complete historical perspective, so one can see where the origin of this base erosion comes from. It must be said that in a follow-up to the case, Takeda sold or acquired the structure, as we said, in 2011, and I think paid something like 9 billion euros for the structure, and that was then paid through to the SICAR and from the SICAR onto the pension funds. So it was a handsome profit that was made. How much base erosion there was in Denmark at the end of the day, I don't know. I don't know how profitable the Danish operating companies were, but it is quite clear that the interest costs would have completely wiped out whatever taxable income they generated if it was deductible against their income. And obviously the interest withholding tax was a handsome addition to the Danish treasury in this particular case. And also remember, this is not just one beneficial owner case, so there are several of them out there. I hope to see you next time at our next case discussion. Bye for now.